a Jaguar car, that association coming from the same company, right? So, the trademark, while I say that you're like, correct, exactly, but you also have to see when you're establishing a business, you also have to see that average man does not connect or associate your trademark with some other company doing some other business. So you have to manage your portfolio in such a way that it differentiate, it create a acquired distinctness between your trademark and a similar looking or exact similar mark in a different field of segment. So that's what actually trademark is. So frankly, yes, trademark is anything which differentiate which defines a person in the marketplace, which make them stand out of the competitors, and which actually tell the customer the differentiation between two. For example, somebody's selling a camphor, name with Lingraj, okay, and somebody selling a camphor with name of, let's say, Ling Balm, okay, and now a person who is going there, both the packets, if look similar, a person of average intelligence should know that I want to buy Ling Raj and not Ling Balm, right? I'm coming here for a product called Ling Raj selling the same camphor, right? So that is what trademark is, basically, to make you stand out in the marketplace and distinguish from your competitors. Now the question comes, like, what all can be trademarked? So like, yeah, as you can see in the screen, the trademark could be a word, a trademark could be a phrase, a trademark could be a symbol, a design, anything which differentiate your goods and services could be trademark. Now, I'll be talking about two laws today. One Indian law, and the other would be USPTO, because USPTO is USPTO is the US trademark law jurisdiction, and it is one of the most difficult, let's say, jurisdiction when it comes to scrutiny of trademarks. Okay, so we'll be talking about these two laws. So I'm starting with the Indian law. And if I go a little too fast, please bargain between you people. Okay. Now, can you all hear me?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
This is all we have covered. So yes, trademark is section 2ZB, although you don't need to like grammar the sections like all the time in trademark. It's like very fancy. Like it's the most fancy law you'll ever come across. But yes, just since we all are law students, so we obviously we have to like have a brief knowledge about what this is. So basically, section 2B of trademark law define what actually a trademark and what can be trademarked. This is that. Then we have discussed this. Okay. Now let's come to the classification. As one of the speakers said, sorry, I don't remember your name. One of the speakers said, the goods are differentiated by classes. Okay. So what are these classes? So a niche classification was created long back, and I don't want to get into history. It's really boring. But a niche classification was created by World Intellectual Property Right Organization, and this classification is being followed by all the countries have being a partner of this particular agreement. So there are around 128 common law countries which are partner. For example, the same goods classification is there in USPTO also, in US also. The same good classification is in UK also. So there is a slightly difference with the law and the language depending on the products when we will be submitting. But yes, these classes are only followed. So these classes basically differentiate your goods and services. So there are 45 classes. Classes 1 to 34 are goods, which cover, like, for example, class 3 covers cosmetics, class 9 covers your electric appliances, class 18 covers your furnitures, 30 covers your food. So all the goods which are there, like the products which are like sold in the market would be called goods, and is between class 1 to 34. Whereas class 35 to 45 are services, like services as a gaming services, law firm services. So they have like different classes for that. Salon services. These all will be covered in class 35 to 45. So when you're filing a trademark, you should be very specific about the classes. Because if you are not filing in the right classes, it do not give you correct trademark protection. For example, if I'm selling, let's say if I'm selling a cosmetic which is which covers like the main proper chemical cosmetics, then I have to like file in class 3 only and not in class 5, because class 5 do give cosmetic protection, but it gives cosmetic protection to the medicated cosmetics, not to the chemical cosmetics. So what if I file in class 5 and I start selling, some lipsticks and eyeliners just like that? So then I won't be getting protection on my trademark at all. If registry or any infringer would come to know, let's say, you're not even selling medicated cosmetics. So like you're just a trademark spotter. So trademark spotter is like somebody who just sits on the trademark, not using it. Take the, so I like, for example, I know that Jaguar is a big company, and I just take trademark of Jaguar in class 30, which sells foods and all, and I don't do anything of it. I'll just take the trademark in my name, get it registered. So then if Jaguar wants to sometime give a gift hampers, and start selling, like, let's say, cookies only in his name, and then they come and file a trademark in class 30, and they say, okay, somebody has already have a trademark called Jaguar in class 30. So then obviously they will have, like, they won't get it, because my mark is a prior mark, and that what the rule is followed in the trademark laws, like in India, that if you get a prior mark, you are the holder of the mark. So then they have to buy it from me, and there's a lot of business strategy and all. So that's why you have to be very conscious when you'll be like filing a trademark, about the classes and the description of the classes that you're filing in the correct class. I hope I'm not confusing, guys. Are you people getting right?
Yes,
Yes,
ma'am.
yes,
Yes,
yes, ma'am.
Please interrupt in between. This is not a classroom. You all are here to learn, so you should, this should be fruitful for you. If you go somewhere, you should be like well versed with the trademarks. Okay. Okay. So now we'll be coming to what all can be the types of trademark, what all can be trademark basically, in what all forms. So one is very obvious, that we can have a word mark, of course. Word mark could be anything, like Apple is a word mark. If you can see my screen, Apple is a word mark. We can take word mark. Dream 11 is a word mark. M-Leak is a word mark. Or let's say Mama Earth is a word mark. So basically, a word mark give you wider protection when it comes to trademark, because when you get a mark on a device mark, it is said that you have right only on the device as it is depicted. Okay. But if you get a word mark registration, you means you can create 100 of device variants, and you can use it any permutation and combination you like, right? So word mark is always the giving wider protection, and word mark is also one of the most difficult protection, most the difficult one when you have to fight from the registry, because it's if the word mark is there, they do a lot of scrutiny. So yes, the one type is the word mark. Then, as we said, the other type is the device mark. So for example, like Kingfisher has filed for this device mark. So their rights in this device is limited to how Kingfisher premium is written, how the, this Kingfisher bird is being flying with the exact color and exact font. It covers all of these areas. Okay. So the other type is the device mark. Then also we get a lot of color marks, like for example, Nika got this mark registered called the pink color. So the pink color app you see in Nika, that's their color mark, and you can get registered for color. In fact, recently they have also released this news called that you can also get the fragrance mark if it's like very famous fragrance. For example, Kannauj Itar, you can also get trademark for the particular fragrance, registering the by submitting the document of their trade secret, which is not like which not gonna infringe their business. So that's how you can get. So that's how there's color mark, there's fragrance mark. Then of course there are like sound mark. So if you all would have heard this. Similarly with Netflix. Okay, so these all are registered sound marks. Okay, so you can take sound marks for whatever particular unique sound you create to distinguish your business. And in past, McDonald's have been so conscious and so protective about this particular sound mark that anybody creating a tempo or music around the song also they have like sued and send in infringement notices. So yes, the other type of mark is the sound mark. Then we come to label marks or three-dimension marks. So these mostly this is so in these kind of mark you also get design protection, but just to be on the safer side and to get a wider protection for your IPR, mostly the cosmetic brands tend to file a trademark applications for label marks also. Example you can see on the screen like Chanel perfume bottle, they keep on filing these trademarks for the bottle as it is depicted. If you see this screen, this particular bottle, how it is depicted, they have filed for label mark for this particular device, and they can also sue the person who has been using such kind of devices, similar looking devices. Also, Ordinary is one of the example. Ordinary has filed 100 of label mark applications for their bottles. Minimalist is the example. I hope boys you're aware about these brands. Boys, are you people listening or sleeping?
Ma'am.
Yes, ma'am. Ma'am, please the name of the brand.
Yeah, I mean, girls must be surely aware about these brands, but I don't know if boys are aware. So all these cosmetic brands tend to file, be blunt, they tend to file these label marks. Yeah.
Excuse me. Ma'am, are these label marks and 3D marks same? You mentioned in the same point.
So when you file a trademark application, so you get an option. If you file for a level mark, then you'll be like how you're seeing the display here, right? It will be only to this particular display. But when you'll file a 3D mark, then you have to give the size of the bottle from all the angles, like from the vertical, from bottom, from top, in the same category, but their protection is different. So when I take a 3D mark protection, then I get protection to the entire view of the bottle from all the angles. But when I take a level mark, then I get protection limited to the level as depicted in the application. Okay. Am I clear?
Thank you.
Okay. Then so after all these marks and all filed, now next question comes that what is the process of trademark registry specifically in India? And when I say India, this is since India also follow, as I said, India also follow the Madrid, WIPO system, World Intellectual Property System. So in most of the countries, this is common and slightly differs here and there, but the concept and the basics are always same. Okay. So I will be telling you with the Indian perspective and how Indian examiners deal with it, but the law remains the same across the globe, who all follows the World Intellectual Property agreements. Okay. So a trademark, when filed, can be rejected by the registry on various grounds. Also, a trademark, how, like we discussed in the morning, that like in the starting of the call, that how a trademark has to be differentiated. What could be the reasons the trademark could be rejected or accepted by the registry, or a trademark could not be a registrable trademark. So what are these reasons that we're going to study? So basically there are two sections in trademark law, and these are the only sections you like need to like remember. That is section 9 and 11, which prohibit your trademark to get registered if it follows any of the category under these two. So section 9 is absolute ground. So in section 9, what happened if a trademark is a distinctive in character? Like for example, I file for a trademark application for mark apple in class 30. Okay, class 30 is food, apple is fruit. So if my mark is of such a nature that it will give the public an idea that what could be my goods or services, that mark cannot be trademarked. Okay. So any such mark, for example, if I say, okay, I get protection on, try to take protection on, let's say, digital sports in, class 41, which is services for online gaming. So I will not get protection because my mark is generic. My mark is way too descriptive in terms of telling the customer that what could be my services. For example, Pizza Hut or Pizza and Company, or like Pizza Express. I file for these application in class 43, which is food services. So my mark would not be, acceptable by the trademark registry, because the trademark law says that you cannot have a trademark which is which define your services. Now the question will come that you will say, okay, Pizza Hut is already registered trademark, okay, or for that matter, even Dream 11 or like any other like biryani, like these are the marks which are descriptive and they're still registered. So how can they get registered, right? So then trademark law also further gives you another, let's say, proviso and exception, that you can get registered to distinctive marks, but then you have to prove that your mark is so famous and so well known that if somebody just Google Pizza Hut, is that your mark only counts. Okay, this is very difficult to convince the registry when it comes to this. But you have to submit extensive evidences, you have to prove your endorsements, you have to prove how much money you have been investing in establishing this brand. But then only thing how you can get a distinctive mark registered in the same class of goods or services which describe it or indirectly describes it or overlappingly describes it, then you have to prove your distinctiveness or well-known status in the market. But on the contrary, if I get mark Apple registered in class 9 for like electronic gadgets, that's completely fine. Or if I get pizza registered for a cosmetic brand, let's say pizza for class 3, I have pizza eyeliner, so that's completely fine. Okay, because that's not describing my services or goods. Now like Apple, say, what will you think if I say Apple? You'll start thinking about gadgets. Now you'll not think about the Apple. That's the kind of distinctiveness they've acquired in the market. Or if I say let's say Body Shop, like the exact thing that will come into your mind will be the Body Shop products, correct? So one ground on which trademark refuses is the distinctiveness. Other grounds are which indicate the quality, kind, purpose. Or like for example, if I say you know uh, Hyderabadi biryani, okay, then, and when I say all these marks, I also mean that these are provided by the acquired distinctness and well-known status as per the trademark law. So other than that, like for example, Delhi basmati rice, or I say Delhi wale bhature, or any such thing like Mumbai Kar cosmetics, more like that, so which describe, or I say like my intended purpose is to like sell like peanuts. So I'll just start say, okay, peanut seller, like a mark called peanut seller or XYZ. So these kind of marks cannot be trademarked. Then where I use the words which are common dictionary language. For example, I start selling something, some food products called honest. What is honest? I mean, honest is a common dictionary word, right? Or I start selling some product called let's say minimal. Okay, minimal is a dictionary word. It's not a coined word. Okay, so you cannot have or like let's say derma. I start selling some product called derma. I might sell a product called Dermi. I might sell a product called the Derma Co. I might sell a product called the Derma People, the Derma Company, anything in and around. Of course, this will be a very difficult marks to convince the registry, and we have to prove a distinctive character in this. But I cannot just file for a trademark, let's say word Derma, or I just like the word honest. So a mark has to be no, it should not be a common dictionary or generic word which is like used in regular day-to-day languages. Then also I cannot, get a trademark register which is like very obscene, or which is a pornography, picture. If I say that the mark which Manpos or like Dulex use and all, that comes under fair use because that's not promoting any obscene matter. But if I go into, if I say obscene, I mean like something which is prohibited under Pornography Act and all. Okay. Then again, I cannot get any mark registered which is a part of our national symbols. For example, lotus. I can't use lotus as my trademark, or I can't start selling a cigarette called Ganesh BD, let's say. Or although these marks do exist and they try to establish to the bracket of acquired distinctness, but uh, 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 on papers and on the facts of the trademark laws, and to like have a successful trademark registration, these particular type of trademarks are not registered. For example, if I start selling some Allah agarbatti, okay, that's not allowed. I mean, that's prohibited as per section 9. Okay. Any questions on this? Any question on the trademarks which are not registrable under section 9?
Yes, yes, ma'am. So you mentioned Allah Agarbatti, right? But that would be registered if, like, it has to be granted if the user has been using the mark for, let's say, 10 years or something. Then what is the
Yeah.
situation in that case?
So for all the topics I've told you, like for all the non-registrable marks, right? The bracket clauses that if they establish the acquired distinctiveness. So now if Allah Agarbatti is there and they prove and convince the registry that yes, we have been using this particular product from past 10 years. See, we have like sale invoices. The products have been in continuously in market. People are buying. These are our purchase orders. These are our like products orders. And we have been if you just Google search us or like basic social media presence, you can see our Instagram account. People are liking, people are following. So these are the evidences which convince, basic evidence what registry asks usually in such situation is because this is not a registrable trademark as per the law. This is prohibited. But as per the proviso, again, you have to prove your distinctiveness. So registry usually asks for the invoices. That if you say that's also you are using now, so then give me purchase order of past 10 years. Even if you're not able to establish 10 years, the registry won't grant you this trademark. But if you're able to establish that yes, I have purchase orders from past 10 years, you'll get this trademark very easily. Any other question?
Right. What is the minimum limit? Like, is it 10 years itself, or is it some other time limit?
No. In general, I might also say, okay, I've been using this mark from 2 years. Okay. And in 2 years, because it's internet era and anything can hit it overnight. So in past 2 years, I've created such a goodwill that, people only think Allah Agarbatti as the only product of the Agarbatti, which is very famous. Okay, so then they, then the registry will ask, okay, show me your, details of past 2 years. I might also say, oh, I'm be using this from past 20 years. So registry will ask, okay, show me details from past 20 years. So there's no specific time limit. But whatever you are like saying, whatever year you are quoting, you have to have a solid evidence to like prove in case of such trademarks.
All right, thank you.
Any other question on section 9? Any other question on section 9, guys? So let's move to section 11. So sorry. Okay. So section 11 basically grant you protection in terms of when there is a prior mark existing in the registry. Okay. So for example, I filed for a trademark application, let's say in class 35 for marketing of a mark called like Swagita in class 35 for like marketing of online products, like online e-commerce website and all. Okay. And then there is another mark called Swagat, let's say in class 35. No matter promoting even there was a Swagat underwear garment thing. Now, so let's say there's a mark called Swagat underwear garment in like class 35, doing completely different business. Okay, I am doing completely different business. I am promoting e-commerce website. They are promoting undergarments and all. But still, if I will file for the trademark, the registry will cite that application and will grant me relative refusal, saying that okay, there is already a mark in the registry. And anybody, a person, how we are discussing about Jaguar now. So, for example, if I say Swagat and Swagita, you might understand because you are a law student, you know what's going around. But a person, a person like your auto driver or cab driver or like your daily helpers around you would be able to differentiate between a Jaguar or like a Swagat or Swagat. Swagita, they will always think like these products to be having an association with each other. So can somebody accept their people in lobby, I believe? Okay, so in such situation, what happens is that when you have likelihood of confusion in the market which created in the public place, registry may not grant you the trademark. Okay. Now, what happens when, what are proviso for this particular section? Because, I am not infringing somebody's business. Now, main to apna e-commerce mein I'm doing business. Somebody is selling undergarments, let him sell. I don't care. How come his business is affecting me? So in such situation, I have to prove the registry that, my line of argument, like my line of business and the cited marks line of business are completely different, and we are not gonna come across to each other, and we are so different that anybody, even the normal man with average intelligence, will not be able to associate our marks. Okay, and this we have to prove with the extensive evidences. And there's a very famous judgment called the Nandini Judgment. Nandini Dulux versus some Karnataka Cooperative Society. You should be like handy with this judgment, because this is your savior when it comes to this section. So you tell this only because in that judgment it was said that two products even having a same name, doing two different kind of business, can coexist peacefully. Okay, so then I have to prove registry that me being here in a same, like Jaguar and Jaguar, like Jaguar selling cars and Jaguar selling electricity, can peacefully coexist, because we are not gonna come across in each other's business. We are doing completely different business. A person who is buying electricity will go to an electrician shop and not to Jaguar car ka showroom, and there is no electricity being sold there. So and the class of people who's gonna buy Jaguar and a people who's gonna buy Jaguar electricity are very different. Not everybody can afford a Jaguar car, right? So then we have to prove these all points when it comes to this ground. Why I'm giving example of section 35, let me tell you, 35 is a section where everybody gets the meat. Okay, this is one that class that everybody, even selling the goods or doing any services, falls under class 35, because 35 is basically promoting and marketing. Okay, a promoting and marketing could be of a furniture, a promoting and marketing could be of the cosmetic products, a promoting and marketing could also be of selling my cosmetic via e-commerce. A promoting and marketing could be opening via showroom and having a concerts. So class 35 is the most a class where everybody can like come and jump over. Okay, let's taking further example. Let's coming to class 43. Okay, There is, as you know, there is La Pizzano, okay, and there's Pizza Hut already existing, or like let's say the Burger King, the Burger Sing, the uh, Burger Sing, Burger. There's like a lot of these the Burger Club. So these are like all common. They like all look same, similar looking. So how these mark got coexistence in the registry? Because they technically they fall in the relative grounds, and the one who got registered first depends to survive, and rest all is liable to be refused, correct? So in this situation, what you have to prove, for example, my mark is like Burger King, okay? So then I'll be, and there's a prior mark which registry come up with saying that, listen, Burger Singh has been registered from past 2 years. Now you're just changing King to Singh, and now you're trying to register the same mark and create a likelihood of confusion in the public. Anybody around you would only think that Burger King and Burger Singhs are associated or the subsidiary companies. So then in this situation, I will have to now my segment of the work is also same. It's not like that, I am doing business in, let's say I'm not doing business in furnitures, and other is doing business in the food. We both are selling burgers, right? And it also falls under class 9, because we are like telling, we are selling burger, we are telling that we are selling burger. So in such situation, this is like most difficult situation to get these trademark. And even when we are talking, if you go and check it online, you will find that these marks are still not granted to these people. They're still lying in the registry. Lately I was also been struggling with one of the client getting similar kind of mark in similar situation, and we are still struggling with the registry to get the mark, just because a word burger is presented and there are cited mark King and Sing and Club, okay? But how can we get these marks registered is one that we have to prove, okay, these marks are so famous, they have acquired distinctness, people associated with them and all. Two, we have to prove that, Burger King and Burger Sing, how these two are differentiated. You need to make a, comparison table saying that, okay, see how their mark look different, how our mark look different, what is the important element of our mark and what are the important elements of their mark, okay? So we have to like tell all of these things to the registry to convince in order to get associated mark. Am I clear, guys? Or any question on this?
Could you please tell the elements of the triple identity test?
Okay. So when triple identity test comes into picture, what one thing, so first thing you have to see around is that, how the mark, so mark has to be taken as whole, okay? So when I say these are my arguments, when I say, relative grounds of refusal. So one, I will be pleading, one thing will be that mark is like seen as whole. For example, my mark is written as, Burger Club, okay? So I have like club ka C capital, E is like small. So like one biggest, like the first primarily test, which is also more like a conclusive test of triple identity test, is that, trademark has to be seen as whole. Burger Singh ka S is written in a small, club and Singhs are not is the same thing. Nobody can claim monopoly on the word burger because it's a common generic word, okay? It's a common word, it's a common word to trade, okay? Then when we cross this stage, then we come to the second thing, is the scope of business, okay? For example, Burger Singh is also doing business of biryanis, or business of selling pizzas or momos, okay? But Burger Club is doing business limited only to burgers. So then the court and the registry will distinguish the kind of services, okay? If the trademark as whole can't be the conclusive, we'll jump to the services of the segments, like more description of the services, or my registry might also ask you to limit your services ki nahi bhai, just lessen it because these people are selling. And the last test is like, if both the two criteria are not fulfilled, then we'll jump to the third criteria, is the likelihood of association, like how much popularity Burger Club is having in the market, how much popularity Burger Singh is having in the market. how much likelihood of association will be created if we also consider the above two factors, that what is trademark has to be seen as whole. What if what is the description of goods and services, and then how public is associating with these two marks, and this all is clubbed with inherent acquired arbitrariness of the mark. So then if all the three criteria are not exactly fulfilled for three the then registry will come up to the question that, okay, what are the, like, then there will be a proper ratio descendant direct, okay, this much particularities are matching, and that's how we can distinguish or non-distinguish these marks. Okay, am I clear, or
Yes,
like
yes.
you have
And
further down?
trade channels would come under likelihood of association itself.
Correct, correct. So trade channel will fall into the third part, when you'll complete associate the likelihood of association, then you'll compare the trade channels. So basically, what is trade channel? If your goods or services are described, you don't need to search for the trade channel now. But for example, my goods and services are also same. My trademark as a whole is also looking similar. My goods services are also same. Now, how will I differentiate that these two marks are different? So if, for example, likelihood of confusion, we have to see now, like, for example, what is trade channel? Basically, trade channel is how you buy or sell the product. For example, Burger King is only selling offline products. You have to go to store and buy the product. But Burger King is a cloud kitchen. They don't have any store. Like, if you want to eat Burger Club, you only can order it through the delivering apps from Zomato or Swiggy. You don't have any other, or their personal app, but you don't have any offline store. So then you'll come to trade channel. This is all fall in the bracket of likelihood of confusion. Like, how much public is associating, how public is buying the products, how they are promoting the product, how they're selling the products. So these all factors will differentiate your trademark. Correct? Are we clear?
Yes, yes. Thank you.
Yeah. Any other question on relative nouns? Should I move on, guys?
Oh, ma'am, I just have one doubt.
Yeah, please go on.
It's just a very silly doubt, but I'm still asking. So I was checking on the trademark registry for both Burger King and Burger King right now. So I was just wondering, like considering you gave the 3 tests, I get it, but I'm just saying it's just a silly doubt. So considering both of them do sell burger, and how does the trademark attorney would actually establish the differentiation between both the companies? Because if tomorrow I come up with maybe burger or XYZ in the market. So since there are already 3 existing competitive markets which are actually selling it in the name which starts with burger, how do I acquire that distinctiveness? Is it only related to that, okay, I sell more than just burger, or my entire project is different from the other? Like, how do I differentiate, or like how do I establish that it's different?
Okay, so this very practical question, it's not at all silly question, it's actually very good question. So frankly, recently I've been struggling with the same thing with one of the client, because our client's mark is pizza and related to it. I can't tell that, but and we have around 18 prior cited pizza marks. Okay. Uh, Frankly, not lying, but the entire trademark registry is just a monkey business. It's so difficult to convince the examiner when it comes to these situations. But theoretically speaking, if I have proven with my purchase orders, or if I've proven with my well-known status available on the social media, no matter there's 100 burger marks in the prior cited mark, the registry will have to grant me. But coming again to the practical aspect, because your question is like very practical, it's actually very good question. So when you file for such trademarks, now your strategy should be one, that you claim a user date, saying that I've been using, let's say your mark is burger fun. Okay, so like you want to use this mark burger fun, and you claim that I'm using this mark burger fun from past 1 year, and this mark, because of the internet, has hit it so much. I am not claiming any right on the word burger. I wanted the mark as it is depicted, and how we suggest our client, when you're taking such generic words, please adopt a device mark, because then we have another argument to keep in front of the registry saying, listen, we are taking a device. We are not claiming any right on the burger or a fun, because these are common generic word. Burger is a common trade work. They're like prior cited marks and all. We are claiming as the mark depicted, as it is depicted with its color combination, logo, symbol, design, whatever. And we have like invested money in it. We'll like put the graphic designer ka bill. See, we have like invested so much money on designing this mark. We'll give the disclaimer that we are not claiming any right on the word burger per se in any way, in any permutation and combination. Then I'll give a lot of purchase orders saying that, listen, this has been like selling, and nobody till date, it has been selling from past 1 year. That's what I claim as my user date. And nobody till date have been confused between Burger Sing and Burger Club or like Burger Fun. And if this would have happened, the companies who are like prior existing would have came to us now saying that, you are infringing our mark. Of course, we are infringing their mark. Technically, their business are being gone. So they haven't come. They are peacefully existing. So let me peacefully exist. So that's how we try to convince. And that's where I was about to come. That's actually it's called like proving an honest and concurrent use, that I'm like honestly using it. I'm not going into anybody's else business. I am doing my own chota sa business. I'm concerned about it, and I don't want a registry to give me any specific right. Today, if you grant me a trademark called Burger Fun, I won't be start, creating a permutation and combination and start selling a legal notice and, infringement notices to every company holding the word burger in the market. I won't be doing that. I assure, giving you that assurity, and I want to do my own business peacefully and coexist with them. If they have any problem, they will come to me at the opposition stage. If Burger Singh have a problem, me registering a Burger Fun as a mark, then they will come and oppose me. I will fight for that matter. I'll prove them how their business and my business are distinguished. So that's how you keep on like proving the registry. But again, trademark registries are like annoying as hell. And even if you prove the distinctiveness, because this is India, and everything has to go like under the table also. Like this is something like you should know if you're becoming a lawyer. So in this situation, registry specifically annoy you. Okay, I'm not giving you this mark. Okay, if you want this mark, like you think of something else. That's the practical thing. But yeah, that's there. Anything else?
Understood.
Actually.
Any question?
Yeah, ma'am, you were saying that there should be prior bills and everything, but what if it's a new company? Like it's just been a week, so what happens?
Again, for example, if it's a new company, of course, I'll be filing a trademark application as proposed to be used basis, correct? But still, when I'll be filing an application, I would have done a market search, no? I would have done, I've invested my time sitting and understanding the kind of business I'm establishing, the use and what kind of business I can get from the kind of company I'm establishing. So this all must have some records, some paper documents. So we'll be submitting all of these to convince the registry. Listen, we are like, because trademark law also say that where a proprietor has invested time and money, then also you need to get the trademark, accepted. Okay, that's another clause. And like if that's like very, very, in detail, when you study trademark law, then you'll understand that. So in such situation, we try to prove registry, listen, we have invested, we have like so much of investment in this particular mark. Although the mark is not in use for now, we'll be using it in future once we are through with the registry process. But I assure that I won't be like infringing anybody's else business. So when the examination report will come, I was about to go there actually. So when examination report stage comes, then when we file a reply, we write all these things to the registry. Listen, we are in the proposed to be used basis. A company is the prior cited company, let's say Burger King or Burger Sing only. They're like existing from long. Even there are like 100 of marks in the registry with the name of Burger. When you granted registration to those people, why not me? Right. So then we will be claiming on these grounds, and depending, this is all very situational. It depends completely on the what kind of, prior cited mark you get. For example, you get a prior cited mark. For example, you get a mark called Pizza and Company registered, and there's a mark called Pizza Express. And the Pizza Express is a, restaurant, and Pizza Company is a cloud kitchen. I will go to, saying that, see my trademark as whole, and, our trade channels are completely different. We are not infringing, and we can peacefully coexist. You don't have to like come at and, ping us for doing this, and we have invested a lot of money. So these are the arguments we, generally come up with the registry to try to convince them when we file the mark as proposed to be use basis. And that's why I said, no, that's, when we suggest our client as a strategy, always try to suggest, by even if you're using in May now, like for example, if I established a business today, aaj ka date claim kar do. But because once you claim a user date now, you have a bandwidth to summarize more evidences in the later stages. Okay, abhi aur use ho raha hai, abhi aur evidence le lo. But when you okay, आपने तो proposed to be उस basis डाला, अभी तो you're not using also ना. So if I reject, then there's no loss to you. You might just modify it and re-amend it and use another mark. It's just an initial stage for you. So that is there. That's a practical question. If I'm able to justify your query.
Yeah, thank
You have further question, you can shoot it. It's not a problem. Okay, should I move on, guys?
Yes, ma'am. Yes, ma'am.
Okay. So now this comes. So again, we came to examination report stage. So what happens? There are like two processes of examination in India. Once like the mark is get accepted or it get objected. We have discussed the objective stage. If it get accepted, it get published in the Trademark Journal. And the Trademark Journal, once it get published, it's open for public scrutiny and third-party opposition. And anybody, for example, then if my mark like Burger Fun got published, anybody, Burger Singh or Burger Club might just come and, file for an infringement application. And yeah, that's how like trademark opposition process goes on. If we get an examination report, we have to file it within 1 month. Okay, next. That's the opposition stage, that once a trademark is published and somebody files an opposition, like if it's filed against me, then I will have to submit my counter to the opposition within 2 months. Then the person who has filed the opposition will submit evidences supporting his opposition within 2 months from my counter. Then same, it will come to my evidence stage, that I will be submitting evidences supporting my counter within 2 months of their evidence. And then again, opponent get another opportunity to submit further evidences, if any. In this case, if they have to like counter any of our evidences and all. They can't submit any new evidences at this stage, but they can counter with the further evidences which comes to this particular stage, and then it goes to hearing and all. So that's actually a trademark prosecution. Sorry, opposition. Now, okay, now similarly, this was like the Indian laws. Anybody have any question with regard to prosecution or opposition in Indian laws? Guys, ask, I'm gonna give assignment, okay? Because if you don't have a question, I don't know what's gonna like. You should not be like confused afterwards. Okay. That means everybody's clear. Yeah, at least say yes.
Ma'am, we understand.
Yes.
Am I too fast? Am I too bored? Okay. Now, okay, let's move to USPTO. So, as I said earlier, now USPTO is one of the most, jurisdiction which scrutinize the marks like anything. Okay, it's very, very difficult, and you have to have like, it's not like an Indian registry that if your mark is just like generic word and they're like prior cited mark, you're just gonna convince the registry in air, and then registry might grant you. No, USPTO people are like very, very serious. And you must have read like most of the judgments of USPTO rejects good applications. Yeah, big clients, they don't care about it. So I mean, and most respectful registry, you know, I really like their working culture. So they have like two systems. One is like a principal registrar system. The other is the superintendent registrar system. So it is exactly like in India how we have exceptions to the refusal grounds. That is exactly we have in USPTO. They have like the superintendent registrar system, and the principal registrar system is like the system where they have like proper verified you know, applications, and they scrutinize everything. And it is very difficult to get the principal registrar system, and the superintendent registrar system does not give you wider protection. Okay, so that system usually people don't tend to go for it. You know, you only go for that system when you know, you cannot justify yourself in the principal registrar system. So what happened here is that when you submit a trademark application, whether you submit an intent to use or like propose to use, or you submit with actual evidence, you have to submit a proper specimen justifying, even if you are going to intend to use it, or you're gonna, you know, just using it. If you're using it, then the boss, you're gone. Like you have to prove with so much of evidence that, you know, you have to prove your concurrent use in the at the time of trademark application only. Even if you're you know, filing it as intent to use, the registry after 6 months will come up to you and say, listen, now you file as intent to use. Now it's 6 months since you filed a trademark application, or prove your bona fide intention of using this mark. So the process of basically registering a trademark is that, you know, in USPTO is that you file a principal application. They, you know, they will verify your the entire process, and accordingly they will issue an office action. Office action could not only be on the basis of refusal, that, you know, a mark should be, you know, a mark should be arbitrary or like suggestive, or like how we discussed, like how we have the relative ground of refusal in class 9. Similarly, the kind of thing they do scrutiny in office action in the initial stage. But also USPTO also issues office action if, for example, your specimen does not, whatever specimen you have submitted does not have a stamp dates, or it does not have the clear you know, justification of the applicant who is submitting the document. So they're very serious about these scrutiny. Even if you submit, for example, Apple as a product, even if you go, Apple is still struggling to get trademark in certain classes, because there are products which like Apple I, which like pre-registered in the registry, and they're like you know, having like being used from like 10-12 years into particular trade and business. So you know, when you're submitting a specimen in USPTO, you have to one, check that, you know, it's properly stamp dated. Two, that, you know, applicant's name is very visible, applicant's description, what you are filing is very visible. Three, that you prove in your specimen and the document you submitted that no, the mark I'm opting is arbitrary. The mark which I'm opting is not infringing anybody's else mark. The mark which I'm opting, I've already conducted a market search, and I've came to a conclusion that there is no other such mark that exists in the registry. So that's all the process. And then, you know, the once the office action is released, then you have to like submit a reply, how we submit to examination, reply to ERs. But it's not like just how we submit, okay, we argued, okay, this is there, and now just grant us. Not like this. Like you have to submit with the legit evidences and proof, and, you know, one office action you have to describe, and you have to justify them why your refusal should not be done on the basis of XYZ attachments or XYZ you know, evidences you are submitting to the registry. Once you fail, you know, you completely fail to like get a trademark register in the principal registrar, then the only you know, process you have to get a, you know, trademark in US is this you know, supplementary registrar system. And in this why people don't go for this, even this get a office action, this get scrutinized and all, but they do give you trademark for some period, like not like, you know, they might not grant you trademark for like how the trademark is granted for 10 years. No, not like that. They might grant you, okay, we are giving the trademark you for like next 8 months, next 6 months, and we'll come back to you after 6 months. We'll again scrutinize your application, and if we don't find that your mark has been justified enough to be a trademark and be in the market, they can refuse at that point of time also. So then that's why but then you don't have any other option if you don't justify the previous office actions in the principal registrar system. So then you left with only this option to get a trademark in US. Now again, trademark can be filed in two ways. One is actual use. Actual use is like claiming a user date, and the other one is intent to use. Intent to use marks are tend to be more difficult, exactly like in India, that if you file a mark as intent to use, the registry, even in the superintendent system or in the principal system, in both the system, registry will USPTO will come to you in after 6 months, and they will re-examine you and ask you to submit the valid evidences of use in past 6 months, okay, and prove your intent to use, that like yes, now since you have got the application and then you've started using the mark, okay. Actual use is when you're submitting the trademark application, you have to prove your actual use, but that does not mean the registry will not check it again. Even in actual use, after 5 years, registry will come back to you, and then he will re-verify your 5 years ka business. He'll ask you that you claim this user date, let's say of 2020. I want to see your business from 2020 till date, and tell me that the marks is actually being used, and you have not just taken the mark and sit on it and not other people using it. So that's how USPTO works. Coming to, you would have heard me saying in this call previously, World Intellectual Property Right Organization, or like Madrid Protocol. So basically, Madrid Protocol is the a common system where from India you can file for a trademark registration to the all countries which are part of World Intellectual Property Right Organization. So for example, UK. UK is called GB, okay. So for example, UK, I want to file a trademark application in UK. I have a mark called Pizza Hut in India, and I don't want to get involved with the local lawyers. I want to save cost now. So I can file for trademark application from India in UK. But what is wrong with the Madrid application is that, if my trademark application in India get rejected, it will eventually get rejected in UK also, because my base application is an Indian application. And if my Indian application, if my house is on fire, how can I rebuild another house? I have to fix my house first and then go to build another building, right? So I have to be very sure that my Madrid application in India is justified. And filing a Madrid application is not a rocket science. It's just you go to IP India portal. There is an option of filing a Madrid application. They give you choices of the countries, and if the class description of the countries is always same, like the countries who are part of World Intellectual Property Right Organization, they have the same class description. Also, you can file a Madrid application. Now, yeah, any question on this, guys? On USPTO law or on Madrid Protocol? Hello. Are you people listening me, or you guys got tired?
No, ma'am.
Okay. So then another thing, big difference, a symbol of TM and a symbol of R. Can anybody tell what does this mean? I mean, the basic idea.
Ma'am, TM says like it's under process and R says it's registered.
Correct. So this, when you're telling your clients this, you have to be very, very specific about it, very, very conscious about it, that trademark, when you file a trademark application, since then you can always start writing TM wherever you use your mark, but you cannot write R, because then it will be prohibiting under the law, because you are just giving an interpretation that your mark is registered, which is not, okay. Once your mark is registered, you can use the R symbol, and this R symbol gives you a wider protection, saying that okay, my mark is registered. This is actually a warning for all the infringers around, that listen, if you're gonna infringe my mark, I'm gonna sue you, more like that. So yes, you should know the basic difference, trademark and the registered mark. Now In general, any question on the session till now, guys? Anybody, any question, any silly question, any practical question, any business dynamic question? Because trademark is like very beginning of any business, you know, it's very important also. So any question, guys?
Ma'am, if I may.
I have a question, ma. Can you hear me, ma?
Sorry, I couldn't get it.
Am I audible?
Yeah,
I have a question.
yeah, one by one. Yeah, shoot your question.
All right, ma'am. In case now under the India Act, I saw that the mark needs to be graphically represented. What in case of maybe a smell mark, if there's something like that, or a tough mark, how can it be graphically represented?
I'm sorry, your voice is not clear. Can you just put your mic a little bit? Sorry, I really can't get you. Wait.
Okay, speak out.
Can you speak again? I can't hear your question.
Okay.
Can you hear me clearly now?
Guys, is it me or anybody else can't also understand her question?
Ma'am, she's not audible properly.
You're not audible.
Yeah, her voice is breaking way too much.
Can you just drop a text? I'll just see your question. Meanwhile, anybody else have any question?
Ma'am, I have a very simple, like a sort of like a clarity I wanted. So, ma'am, recently, like a lot of like on LinkedIn also, there are a lot of posts regarding how Mickey Mouse copyright will be in the public domain by 2024, but a lot of them are claiming that the trademark would still be with them. So like I'm not very sure, I'm not very research oriented on this, but would you be able to tell us, like, you know, which part of like the Mickey Mouse is trademark? Like, is it the mouse or the name or the mark or the word mark is registered?
Okay, so they have multiple registrations. Also, one of our bloggers gonna come up with this blog, and it's very interesting also. So he has touched this aspect also. Yes, they have complete protection on the trademark. Trademark, when I say they have a word mark also, they have device mark also, they have label mark also. So they have complete protection on. So anybody using Mickey Mouse or like Mickey Mouse Clubhouse or Mickey Mouse Wizard. Basic the Mickey Mouse things, they can definitely sue for trademark infringement. Nobody can start selling a Mickey Mouse t-shirt or the Mickey Mouse company. That's not what Mickey Mouse have been came into public domain for. The only thing which is gonna be in public domain will be the Mickey Mouse ka picture. Okay, so what was happening was that, you know, Mickey Mouse is so famous, so people make Mickey Mouse cakes. Mickey Mouse are there like in phone covers and t-shirts and all. So these people and they have Mickey Mouse ka picture as a copyright. Okay, so they started selling people copyright notices. Okay, you're like infringing my copyright and trademark. So now what is happening, just the picture of the Mickey Mouse as defined in the suit into particular angles, that will be in public domain, so that anybody making a Mickey Mouse cake or like Mickey Mouse t-shirt will not be an issue. But somebody writing Mickey Mouse or like starting a company saying a Mickey Mouse company will definitely be infringement of the trademark and will be sued. Okay.
Yes.
Okay, so okay, yes. So yes, smell mark is a very recent judgment which came, where they say the marks which are like extremely the smells which are like extremely famous, like for example the Kannauj Itar. The Kannauj Itar is like worldwide famous. It's come with this small bottle and they have this unique fragrance and nobody knows the trade secret till date, but everybody is trying to touch around this, the kind of pregnancy what happens around. So yes, now the registry said in such marks, people might claim the smell, the trademark for the smell also. Of course, they won't be submitting their trade secret, how they create that smell, but yes, they have to submit the basic formula, which is not gonna infringe their right, so that their rights are protected around the mark. Okay. When it comes to the touch mark, it is very situational. Again, this is very depending on, like for example, you remember there came in between, I don't know if you guys know this, came this jelly like a ball, okay, which was very pompy, and you can and it came as a depression remover, or more like and do you guys remember that like furry ball which came in between? Do you people remember? Anyway, can you see in Instagram they came with this another soft toy which you can reverse, like reverse in a bad mood and a good mood. It's like a lot of promotion.
Yes. Octopus thing.
Yes, ma'am. Yes.
Exactly. So, for example, in such situation, you can file for a trademark for how the octopus is looking as a 3-dimension into all the shape and size and turning it. That's not a touch mark. There's nothing called touch mark. That's actually fall into 3-dimension. And you can take, to protect the touch thing and like how you reverse it and all, to protect that, you can take a design protection and not a trademark. That's there. If that's answer your query for smell mark and touch mark. Am I clear? Guys, बोल तो दो. I feel so bad.
Yes, ma'am.
Okay. Okay. Now I want you to people do this assignment. Okay. Let's say our mark is the IP press. Okay. And somebody started another business with the with the kind of same in the same segment with the mark called IP print. Okay. And I want you to people prepare a kind of sending a legal notice covering all the sections, relevant sections, section 9 and section 11. Do a little bit more research in trademark laws. You'll find a lot more than that. Section 18, section 12, section 29, 102, 103. And I want you all to prepare a detailed legal notice which will be sending to the IP print and a hypothetical organization for infringing our mark, the IP press. So you have to prove how our mark is being infringed. You have to prove, how it is affecting your business, and you have to prove their bad intention of avoiding a mark which is, phonetically, visually similar to our mark. Okay. For your example, an IP print is a hypothetical organization having, who is also a non-profitable organization having same kind of, kind of business. Okay. And I want to, let's see who gets the best legal notice, whose lawyers get active more. Okay.
Okay, ma'am.
Yes, ma'am. Yes.
Any other question, guys?
No, ma'am. No, ma'am.
Are we done? Mane, are we done? Okay, I think we are done here. If we don't have any further question, then okay, you also enjoy your weekend. I'll also just go do something around my IPs. I use my phone having a trademark called OnePlus, and then do some fun around the weekend. Okay. Okay, guys. See you.
Thank you so much.
Thank you so much.